This is an analysis from Alpha Business Media.
Welcome back to the deep dive. You've sent us your essential sources, internal memos, legal analyses, the works, and today we're unpacking a monumental strategic risk that should be mandatory reading for every single director in Nepal.
It really should.
We're talking about the Social Security Fund, the SSF, and how compliance failure has suddenly shifted from being, a routine corporate fine to a direct threat against personal assets.
That shift is profound. For years, SSF compliance was it was handled deep within HR or finance. It was treated almost like a checklist item.
Something you just get done.
Exactly. Now, your sources clearly show it's moved right to the top of the corporate governance agenda. It's no longer about paperwork. It's about personal risk exposure. Our mission today is to distill the legal mechanisms that prove this, to analyze exactly why directors are now on the hook when SSF contributions go unpaid.
And the findings in this material are, they're dramatic. This isn't just about an increase in regulatory scrutiny.
No.
It's a redefinition of the entire risk framework.
Absolutely. And if we zoom out, there are really three non-negotiable takeaways you need to internalize immediately from these reports. First, that protective corporate veil that shields directors, it's thinning dramatically, at least in this specific context.
Meaning your personal house, your car, your assets are no longer safe from the company's non-compliance debts.
Precisely. Second, the single biggest landmine, the thing that will trigger the most liability, is this huge gray area of misclassifying employees as consultants. It risks catastrophic retroactive penalties that nobody has budgeted for.
That's the one I keep circling. Seems like the biggest hidden threat.
It is. And the third point, which, pulls all this together, is that SSF compliance has left the realm of simple HR administration for good. It is now a mandatory governance and fiduciary duty metric that directly impacts director liability, corporate valuation, everything.
Okay, so let's start with that fundamental concept, the corporate veil. It's the engine of modern corporate law, right? This legal shield separating the company from the people who run it. Think of it like a protective layer of tough glass between your personal finances and the business's debts. How exactly does SSF non-compliance manage to provide the specific legal crack needed to shatter that foundation?
Well, it's cracked because of specific language in the SSF Act of 2017, which targets the officer in default. But the real severity, the real teeth, come from how the courts are reframing the offense itself. They aren't looking at a systematic SSF failure as the company simply failing to pay a tax or a standard debt.
Okay, so if it's not a debt, what is the legal definition they're applying here? What does it become?
It's viewed as the systemic misappropriation of funds that legally belong to the employee. The moment an employee's contribution is deducted from their salary, that money is held in trust by the employer. It's meant for immediate remittance to the SSF. By failing to deposit it, the employer isn't just stiffing the government, they are, in the eyes of the law, taking the employee's money.
So you've moved it from a simple financial default or a bookkeeping error to a breach of fiduciary duty. That is a massive distinction in terms of personal culpability.
It fundamentally shifts the charge. It's no longer a civil debt. It's a quasi-criminal act of willful negligence or, a breach of trust. Now think about the common defense that directors rely on, especially non-executive directors.
I wasn't involved in the day-to-day operations.
Exactly. But that argument starts to crumble here.
But wait, isn't that why we hire finance directors, CFOs, and compliance teams? If I'm a non-executive director and my role is governance oversight, how am I expected to personally police this detail without becoming operational myself?
That is the critical question the sources address, and the answer is pretty unsettling for directors. The SSF mechanism argues that sustained non-compliance, a pattern that extends over months or years, it just can't happen without either the board's knowing sanction or a catastrophic failure of oversight.
Okay.
The board's ultimate job is governance and oversight of the organization's fundamental processes. This is a fundamental process.
So the defense of ignorance is no longer a defense of innocence in this context.
Not anymore. The officer in default provision is designed to find accountability where the corporate structure failed. Who signed off on the financial statements that masked this liability? Who approved the lack of budget or process for compliance? In this context, the officer in default could be the CEO, the CFO, or even a board member. The risk is now targeted and personal.
Okay, so if the crack in the veil is the officer in default mechanism, the explosive charge that fills that crack is this widespread abuse of consultancy agreements. This is, without a doubt, the single greatest source of hidden liability for businesses in Nepal right now.
It truly is the ticking time bomb these reports flag. And everyone knows this practice is common, hiring someone for a full-time core role, but labeling them a consultant on paper to avoid SSF, gratuity, all those other statutory benefits.
So the company has a piece of paper that says consultancy agreement, but in reality?
In reality, it's an employment relationship, and for a long time, the enforcement focus just wasn't there. But the legal doctrine being sharpened now is substance over form. The Department of Labor and the SSF will absolutely disregard the title on the document. They'll just look at the actual operational relationship.
Give me a brief scenario. What does this look like when the SSF actually comes knocking?
Okay, think of a growth stage tech startup. They've hired 5 consultant software engineers. They pay them a regular monthly retainer. They all have to attend the mandatory Monday morning meeting. They log into the company VPN from a company-provided laptop. And they need HR approval to take a day off.
That's an employee.
It's employment in all but name. The contract title is a feeble defense, at best.
The sources suggest the penalty is, well, catastrophic. It's not just paying tomorrow's contribution, is it?
No, it's years of retrospective action. A successful reclassification means all those years of consultancy fees are legally deemed to be salary. The company then becomes liable for all the unpaid contributions, both the employer and employee share, plus massive fines and accrued interest for the entire period. This can stretch back years.
That's an unbudgeted, potentially company-crippling financial liability.
And this is where it circles right back to personal risk. Once that catastrophic default happens because of systemic misclassification, the directors who oversaw or, just allowed that practice to continue become prime targets for legal action.
Which makes the need for a self-audit critical. For you listening, sitting in a strategic meeting, how can boards definitively test whether their consultants are actually employees in the eyes of the law? We need a clear, practical checklist.
We do. The sources compile 4 clear legal tests, which are derived from global labor law principles, but are now being applied directly in the Nepali context. We have to look past the paperwork.
Okay, let's start with the most traditional one, control. What does that analysis look like?
So the control and supervision test asks a simple question. Who is in charge of how the work gets done? If the company dictates working hours, mandates office attendance, provides detailed, micromanaged instructions on how the work must be done, that person is an employee. A genuine consultant is hired for an outcome. They are the master of their own process.
Right, an independent contractor.
Yeah.
But what about when contractors work almost exclusively for one client? How does the law handle that kind of economic dependency?
That brings us to the second test, the financial integration test. We have to examine the economic reality of the worker. An employee relies on a fixed, predictable salary. A genuine consultant, on the other hand, operates a separate business. They issue invoices, they bear their own profit and loss risks, and they often work for multiple clients.
So if your consultant gets a regular, fixed monthly retainer that makes up their entire income.
They are financially integrated. They are, in the eyes of the law, an employee. They lack the necessary economic independence.
Okay, moving on to the operational side, the tools of the trade.
That's the tools and equipment test. It's simple, but it's a powerful indicator. Who provides the resources? Employees get the company laptop, the corporate email, software licenses paid for by the firm, a desk. A genuine contractor brings their own professional infrastructure.
Okay, so pretty clear lines there. And finally, what about the nature of the work itself? Does it matter if the work is, permanent and core to what the business actually does?
It absolutely does. This is the integration and core function test. If the individual is performing a task that is permanent, continuous, and essential to the company's core business, say the full-time chief technology officer or lead financial analyst, the risk of reclassification is highest. Consultants should be for ancillary, temporary, or project-based work.
That makes sense. So to understand where this is all going, the sources strongly emphasize looking at India's experience with its Employees' Provident Fund, the EPF. Why is the Indian judicial trajectory such a reliable crystal ball for Nepal?
Because Nepal's courts often reference and adapt Indian legal precedents, and India has spent decades grappling with this exact director liability issue, their experience provides a really clear 3-stage roadmap for what's about to accelerate here.
Okay, so let's walk through those stages. What was the initial judicial phase like in India?
For a long time, stage 1, the Indian courts were very conservative. They were highly deferential to the corporate veil. Prosecutors had to prove a director was personally and directly involved in the decision to withhold funds.
So a very high bar for regulators.
A very high bar. Directors could generally avoid personal liability pretty easily.
And when did that legal standard shift?
That was stage 2, the dramatic shift. The Supreme Court started broadly interpreting the term person in charge, and crucially, they adopted that fiduciary trust definition we talked about. They ruled that non-payment wasn't just a debt, it was a breach of trust because the money belongs to the employee. That single interpretation allowed them to pursue oversight failures, not just active participation in fraud.
So where is the judicial standing now in India? And by extension, where is Nepal heading?
We are now firmly in stage 3, where the burden of proof has shifted entirely onto the directors. The courts essentially assume that non-payment is prima facie evidence of negligence. Directors can no longer successfully plead ignorance or just say, oh, I'm a non-executive director.
So what does that look like in practice for a non-executive? What does demonstrating all due diligence actually entail in this legal climate?
It means they have to show documentary evidence. They need to prove they actively asked management-specific, pointed questions about SSF compliance in board meetings. They reviewed the compliance reports diligently. They demanded assurances from the CFO about contractor policies, and they minuted their concerns if they suspected a gap.
So it's not about whether you were involved in the action.
No, it's about whether you were involved in the oversight failure.
And that is the crucial predictive value here. The sources suggest that what took 20 years in India could become the standard in Nepal in the next 3 to 5 years. An accelerated timeline.
It's almost a guaranteed outcome. The legal framework is proven, and just waiting for the right test case to set the new precedent here.
So let's talk about that strategic outlook. What are the 2 most likely paths for SSF enforcement in the short term, according to the experts?
The material outlines 2 possible trajectories. The first, and most probable, is what they call enforcement by example.
Meaning?
The SSF will strategically target a few high-profile companies with clear, long-standing patterns of non-compliance. They won't just issue a fine. They will make a concerted effort to name and pursue individual directors in legal actions, aggressively using that officer in default provision.
That creates the necessary legal test case and, of course, the media coverage to spur a panic-driven compliance wave across the market.
Exactly. The shockwave forces everyone else to clean up their books. The second, more optimistic scenario is proactive clarification, where industry bodies lobby the government for clearer safe harbor guidelines for classifying workers.
But that clarification only helps moving forward. It doesn't offer any amnesty for past violations, does it?
Correct. It offers clarity for the future, but it offers no parting for companies sitting on years of retroactive liability. That exposure remains.
So what is the personal bottom line, the hard truth, for every director on a Nepali board right now?
The hard truth is that the era of plausible deniability is over. SSF compliance has transitioned from a delegable administrative task to a core governance responsibility for which you are, at the end of the day, personally accountable.
And the risk isn't just the accrued fees the company might face.
No, the real risk is the unquantifiable legal expense and personal financial liability that your standard directors and officers' insurance, your D&O policy, may not even cover.
Why not?
Because non-payment is being framed as a breach of trust or a willful statutory violation. Most standard D&O policies have explicit exclusions for intentional willful acts. The risk now matches directly to your personal assets.
So every board member needs to be asking this in their next meeting, right now.
They need to ask, can I personally certify that every single person working for this company is correctly classified using those 4 tests, and that all their statutory SSF dues are fully paid? If the answer is anything less than a resounding yes, you must quantify your personal exposure immediately.
That brings us to the end of this deep dive. The central point we extracted is this. SSF compliance is now a critical test of corporate stewardship with direct personal consequences for directors in Nepal, driven primarily by that massive gray area of consultant misclassification.
And if we connect this to the bigger picture, this enforcement action centers on the courts defining the employer's duty regarding employee funds as a matter of fiduciary trust. This raises an important question for you to mull over.
Go on.
If the judicial focus is now firmly fixed on fiduciary trust concerning employee funds, what other statutory obligations that we currently see as merely administrative, like timely tax remittances or mandatory safety disclosures, what other things might similarly trigger this kind of accelerated personal director liability in the future if they're persistently breached?
A powerful thought to close on. Thank you for sharing your sources and letting us dive deep into this critical issue. Now, go apply this knowledge.